Good morning, everybody, and welcome.
Good morning.
All right, let's see here. Before we begin, we're just waiting on a few more people to join us. Alrighty, it looks like we're ready to go. Good morning. My name is Jessica McClellan, and I'm going to be your moderator for today's session. Everything you need to know about the latest COVID stimulus bill, which is actually a law now. Before we begin, a few housekeeping items. I would like to ask that if you could please turn off your cameras. We'd really appreciate that in order to uh, reduce the disruption. In addition, everyone will be on a listen only mode. To ask, there will be a question and answer session during the end of the presentation with questions that are submitted via the group chat feature. If you look to the right-hand side of your panel, you should see a chat box where you can submit questions at any time during the presentation. Type your question in the dialog box and click send. We will attempt to get through as many of these questions as possible. Finally, a recording of today's webinar will be made available for everyone who has registered for this event. It will come in an email later this afternoon or early tomorrow. All right, with that, let's get going. On December 27th, President Donald Trump signed into law the Consolidated Appropriations Act of 2021, otherwise known as CAA. It is the second largest stimulus bill in modern history. The massive law provides additional economic relief to individuals and businesses. It expands the employee retention credit and changes the Paycheck Protection Program, along with offering a new round of PPP loans. Today, we want to share with you an overview of the Act and some of the significant provisions which will surely impact some of our listeners. With us today, we have a stellar panel, which includes Kate Matz, a WVC partner and leader of the PPP task force. In addition, we have Mike Hanf, a partner in our tax department and a member of our PPP task force. With that, I pass it over to Kate.
Thanks, Jessica, and welcome again, everyone. Just as a recap, we are going over PPP updates as well as the PPP2 program that was announced, some other updates that came out of this most recent law, and we'll spend a fair amount of time talking about the employee retention tax credit. Not new, but was extended and expanded. So this is going to be something that's going to come into play for a lot more businesses now under these new rules. So high level, what was in this act? So what was in here? Big dollars, so $900 billion for COVID-19 related relief, another $1.4 trillion for federal government spending. So they kind of wrapped all this into one big funding bill. Things that were in there, we've kind of already talked about: PPP, some extensions and expansions to some tax credits that had been kind of already out there, and then some other various COVID-19 relief programs. There are a handful of things that were discussed, but ended up not making it into the final bill and law. That was some additional state and local and tribal funding, as well as the liability protection against COVID-19 lawsuits, and then federal student loan forbearance. So you may have heard a lot in the news kind of leading up to the end of December about those areas, but those did not make it into the final law. So let's spend some time here diving into the PPP loan section. So here's just the quick headlines. On the eligibility side, so they reopened this for first-time applicants. So this thing came out of the CARES Act back last March and had round one of PPP loans. Funding ran out. They opened it back up then in the summer of last year for kind of a round two. Now with this new CAA, what they've done is opened it up once again for a round three of people getting first-time loans. So reopened it for these first-time applicants. It was also expanded into the 501c6s. So these are organizations like your chambers of commerce, economic development organizations, things like that, that were not previously eligible. the eligibility has been expanded to include those organizations this go around. And then also it is allowing for a second draw, which we're calling PPP2 for certain businesses. On the forgiveness side, then, the really big headline is tax deductibility. So this has been a big question that was out there pretty much from the get-go. So written into the original CARES Act was that the PPP loan itself and then forgiveness on that was supposed to be tax deductible. The IRS came along later and said, we've got kind of different idea on that, Congress. And they released some guidance that said, no, we're going to kind of enforce these areas of the tax code that say if you get tax-free or if you get kind of forgiveness on your debt or cancellation of debt, anything that was expenses that went towards that are going to not be deductible. So that's been a big question mark out there as far as what was going to happen. And it did get through as part of this final act that in fact, all of the PPP loan, the forgiveness, and any sort of expenses going towards that forgiveness are not going to result in a tax bill. So big win for businesses on that one. They also added some additional eligible expenses on the forgiveness front. And we're going to go through all of these in more detail here as we continue to go. Streamlined forgiveness process for loans that are $150,000 or less. And then also made the EIDL advances no longer offsetting your PPP forgiveness. So those are kind of the headlines. We'll kind of get into a little bit more of the details here. So this is just first a bit of a comparison of these different PPP programs to try to get things a little bit straight in your head. I know it gets a bit confusing. So we've got our Paycheck Protection Program umbrella. Underneath that, there's a PPP1 program and a PPP2 program. So PPP1 is what we're calling the first draw loans. So if you haven't gotten a loan before, the first time that you get a PPP loan, it's going to fall under this PPP1. So again, it was started as part of the CARES Act, less than or equal to 500 employees. You had to be eligible for SBA 7A loans. You had a max loan amount of 10 million, and you could apply during the period of March through August of last year. The CAA reopened this PP1 program for these first-time borrowers. Very, very similar provisions. This is where, though, it did expand it into allowing those 501c6 organizations to apply as well. And the time frame for application for this is going to be January through March of this year, or until funds run out. There is a designated dollar amount of funds allocated. On the PPP2 side, then, this is those second draw loans. So you already got a loan under PPP1, and now you're going back for a second draw. So in this case, the eligibility requirements are more restrictive. So now we have 300 employees as the cap as opposed to the 500. And you have to show that you've got a 25% or more decline in your gross receipts. Again, you would have already had to have a PPP1 loan that you've used, and the maximum amount for this go around is going to be $2 million. So this is kind of the high level snapshot as far as how these things are similar and how they're different. Now we'll get into the details. So we've got here this PPP loan application guide. It's kind of our roadmap on how to think about what the application process would be for going to get a PPP loan. So when we start out here on step one, the first question to ask is, did you already receive a PPP loan? If not, then you're going to be eligible to apply for PPP1 under the CARES Act with some slight amendments made by this CAA. If you did already receive a PPP1 loan, then you're going to look at if you qualify for a second draw or a PPP2. A couple of other points to note here with this CAA, they did open this up for some supplemental funding requests in certain situations. So partnerships and seasonal businesses, for example, the rules kind of changed along the way as far as how you calculated the maximum amount of the loan that you were eligible for. So if you were one of the early applicants and the way that you calculated it didn't maximize your loan amount, you are able to go back now and request those additional funds to get up to that maximum amount. There's also a bit of a do-over provision. So if you're a borrower who was approved but decided not to take it, or if you returned all or part of the loan the first go around, you've got the ability now to kind of go back and say, you know what, I'd actually like all of that I was eligible for and approved for the first go around and I didn't take. It does not appear that if you made a mistake, though, during your calculation of your loan amount the first go around, that you're able to go back and fix that. So it looks like these supplemental funding requests and do-over provisions are really specific to a ruling that had changed along the way, or if you, like I said, returned part of the loan, you've got kind of the ability to go back and request more. So once you answer that question for step one, that is going to put you either on a path for going down the PPP-1 road or the PPP-2 road. So let's take a look at what step two looks like for each of those paths. So if your answer to step one, did you already get a PPP loan, is no, you're going down the PPP-1 path still. So here you're going to use all those same criteria that have been in place for the last 9 months coming out of the CARES Act. Again, we have these eligible 501c6 organizations as kind of the new thing added here. Couple of reminders, the employees here, you're really looking at the average headcount for 2019 or the last 12 months to see if you meet that employee criteria. And there's also the SBA size requirements by industry. So if you don't meet it by the number of employees, if you are an industry that has that alternative size requirement by the SBA or size ruling, you're able to use that instead. On the flip side, if you're looking at PPP-2, this is where we get a little bit more restrictive. So we've got instead of 500 employees, it's a 300 employee max. As a nod to some of the most hardest hit organizations, the accommodation and food service, this is on a per location basis. So if you've got multiple restaurant locations or you're a hotel that's got multiple locations, you are going to look at this employee threshold on a per location basis. New here again is that 25% decline in quarterly gross receipts. So what you're going to look at here is pick a quarter in 2020 and compare the gross receipts for that quarter to what your gross receipts were for that same quarter back in 2019. If you have at least a 25% decline in 2020, when you can do that comparison back to 2019, you meet this criteria. So some flexibility as to which quarter you pick there, so you can kind of run the math and see if one of those gets you over the hurdle. Interesting to note, if you are applying for a loan under $150,000, you actually don't have to show your math on the application end, but you are going to have to prove it when you go do the forgiveness. So I'd say for all loans, just do the math, make sure that you really meet this criteria of 25% decline in quarterly gross receipts. Last bullet point there, kind of in the box, again, is that you must have fully used your PPP-1 loan to be eligible for PPP-2. So by the time that the PPP-2 loan is going to fund, that's kind of the cutoff for when you must have used all of those PPP-1 loan funds. So what you can't do is, if you haven't already gotten a PPP loan, you can't apply for one right now and then turn around tomorrow and apply for a PPP-2 loan right away. You would have had to have gotten that PPP-1 loan earlier and used up those funds in order to be eligible for PPP-2. Employees are being measured same type of way, average headcount. It doesn't appear that the kind of alternative size requirements are in effect for PPP-2, since it's referencing as 300 employees. That appears to be that it is a straight 300 employees across all industries. For the gross receipts, they are using the SBA size rules for gross receipts and how you calculate that. But there is a note that your PPP 1 or EIDL proceeds do not count as part of those gross receipts. A question mark that's out there is if you need to meet this necessity requirement for PPP 2 that you did have to certify to on PPP 1. So if you remember back on PPP 1, there was a certification that there was current economic uncertainty, and that made it necessary for you to get that loan in order to continue your business operations. It's not clear whether you're going to have to make that same certification for PPP 2, or if that 25% decline in gross receipts kind of takes the place for that. So we'll continue to monitor for more guidance. There was some guidance that was released last night around 11 o'clock. It did not clarify that point. So we'll have to kind of see as more things continue to come out. So that is step 2. If we move on then to step 3, so we've kind of already decided if we're on the PPP 1 or PPP 2 path, and then we've gone over our eligibility. Now it's time to calculate our loan amount. So if we are on the PPP 1 path, our loan amount is going to be calculated the exact same way as it has been up until this point. So you're going to look at your average monthly payroll and take that times 2.5, maximum loan amount being 10 million. If you are down the PPP 2 path, you're going to calculate it the same way, average monthly payroll times 2.5. Maximum loan amount here though is only 2 million instead of the 10. Now, back to the accommodation and food service industries that have been the hardest hit. There's a little bit of an accommodation here for those folks. The multiplier instead of 2.5 is 3.5. It is still maxed out at that $2 million though per loan. All right, so once we get through calculating the loan amount, step 4 is going to be to go ahead and apply. So you're going to apply through a participating lending institution, just like you did for PPP 1. So go back to your lender that you used the first go around, or if they're choosing not to participate, you can use a different lender if you want to do that. But these will go through the banks again. Expecting applications to be available sometime in January. So as of right now, the SBA and Treasury haven't released the new form. That should come out sometime middle of the month. And then the banks will have to kind of go through their process of getting their internal systems built so that they can accept those. So sometime in January, those will be available. What you can do now though is go through this roadmap and see if you do qualify, calculate your loan amount, get all of your documentation pulled together. So when those applications do open up, you'll be ready to go ahead and submit that. All right, so that is on the application side. Now this next roadmap walks through forgiveness. Not too many changes on forgiveness from what we've been seeing with PPP. So we'll do kind of a high level overview of that and just highlight what those couple of changes are. So first step on forgiveness is to determine your covered period. The change here is that instead of having to choose 8 weeks or 24 weeks, it's any length in between the 8 and 24. So you kind of get to pick your own within those constraints. It hasn't been explicitly stated yet, but I believe that when you kind of have to pick this, between 8 and 24 weeks, you're still going to need to think about that prorated amount of payroll that's going to be capped for your eligible expenses. So it's $100,000 annualized, and then you've got to prorate that down to whatever period you choose between that 8 and 24 weeks. So it was a little over 15,000 on the 8 weeks, a little over 46,000 on the 24 weeks. If you choose something in between, you're still going to have to kind of do that math on what that prorated amount of eligible payroll is going to be. Step 2 then is going to be looking at your eligible cost. So the new thing here is we've added 4 different categories of additional eligible non-payroll cost. So they've got covered cost of operations, property damage, supplier, and worker protection. On the operations side, this is aimed to help out businesses with whatever changes they needed to make, or even ongoing expenditures they needed to make to operate remotely. So software or cloud computing services that facilitated any part of your business operations, be it accounting, HR, payroll, the actual physical operations, but any expenses that you had on cloud computing services or software would now be an eligible cost. Doesn't appear that it includes hardware, but just software and the service side of things. Property damage then would be, unfortunately, if you had any sort of vandalism or looting due to public disturbances, that would also be a applicable cost here under the covered eligible payroll cost. Supplier costs then would be any goods that were essential to your operations. And if you had a contract for those that was in place before your covered period and was continuing that on, so you needed to continue to pay those according to your prior contract. Or if you are in an industry where you've got perishable goods, those contracts could have actually been entered into anytime during your covered period as well. So again, a nod to some of those hardest hit industries with the restaurants and accommodations. On the worker protection side, then, this is going to be anything that you had to put into place to make things safer, basically, for your employees, comply with government mandates or guidelines to help out with COVID-related measures. So if you bought PPE, if you had to put in, like, say, a drive-through, if you expanded your space, if you had costs to do health screenings, any of those sorts of costs are going to be eligible here for this worker protection non-payroll cost area. Now, we still do have this requirement of your payroll costs needing to be 60%. So these eligible non-payroll costs, even with these additional ones, still can only represent 40% of your total loan amount in order to get full forgiveness. But there is something here, and Mike's going to talk more about this, but there's an interaction now with this employee retention credit that didn't exist previously. So before, you kind of had to pick one or the other, PPP or employee retention credit. Now you can do both. So as Mike's going to explain, what we saw before was a lot of people on the PPP forgiveness were just kind of loading up all payroll costs and not taking the time to go through and add in the non-payroll cost. If you qualify for the employee retention credit, there's now an incentive to not do that. You're actually going to want to throw in these eligible non-payroll costs as well and make sure you've got enough payroll costs that you can count towards that employee retention credit. So it's an important point to note.
And if I may add one point of clarification.
Yeah.
If an individual, if a company filed for PPP forgiveness and simply put in $500,000 of payroll, but only needed $250,000 to obtain the forgiveness, there's not clear guidance out there for that specific scenario. But our belief is those additional dollars that were not used for forgiveness are still going to be available for the employee retention tax credit. But what Kate said is absolutely correct. So there's the distinction I'm trying to make is if we didn't go and get the other category of costs, the end result will be less dollars for the employee retention tax credit. If we simply put more payroll cost than what we needed on the application, that in of itself will not reduce the dollars available for the employee retention tax credit.
Yeah, thanks, Mike. Moving on to the next step then is this 60% payroll requirement, calculating that out. Nothing changed there. Next step then is going to be looking at was your loan amount not more than $150,000. So this is new with the CAA. There is a simplified form and streamlined process that will be announced later, and further details coming. But basically, this is going to be if your loan is $150,000 or less, you're just going to have a one-page certification that you turn in for your forgiveness application. Couple of things that you'll have to note on there: number of employees that you retained because of the loan, the estimated amount of loan that you spent on payroll, what was your total loan amount. You still are going to need to certify, though, that you are in compliance with all of the other PPP forgiveness requirements. So this isn't automatic forgiveness. It's as close as we're going to get, but you still are certifying that you meet all of the other requirements. You just don't need to show your math on that. You are going to need to keep your records, though, to prove that out for 4 years on the employment side, 3 years for other items in case you are pulled for audit. So this new form is supposed to come out by the 20th of this month. So the next step then would be step 5. And this is if you don't, or if you have a loan that's over that $150,000, you're going to look at step 5. It says, do you meet the easy application criteria? So that's still out there. This is available to borrowers of any size. And this is just looking at criteria of, did you have reductions in FTEs or compensation, or if you had reductions in FTEs, but they were because of government mandates, there are ways that you can qualify for this easy application. So that'd be the next thing to look at. If you don't meet that $150,000 one, if you've got that loan above that, is there a way that you are eligible for this easy application that will make things much more simple for you? If you don't meet that, though, then you're on to step 6, and this is where you're having to go through the full calculation and the long form. No changes here. The same wage reductions and FTE reductions continue to apply. That would bring us then to step 7, which is going to be calculating out the forgiveness amount. So it's going to be the lesser of the loan amount that you received, the 60% payroll requirement, or the eligible cost that you would have calculated in steps 2 or 6. So nothing changed here. But again, the new things with the CAA, this forgiven amount, not taxable. For pass-through entities, owners of those pass-through entities are going to get an increase in their basis for the forgiven amount, depending on the timing, though, of when you applied and got your forgiveness. It might not all kind of match up in the same year. So that'd be something to kind of work through with your tax advisor based on your specific situation. All in, you will get that increase in basis. It might just kind of take an extra year to get there. And then the other piece about forgiveness is it is no longer reduced by the EIDL advance. So that was the up to $10,000 that you could get as an advance on the EIDL. If you applied for the EIDL, that portion was a grant, and previously it was going to reduce any forgiveness amount that you were going to get on the PPP. It's no longer reducing the PPP forgiveness. So you get forgiven whatever your PPP loan was, as well as that EIDL advance. Also, they did run out of funds for the EIDL advance. So if you applied for an EIDL loan and you did not get the advance because they ran out of funds, they have replenished that funding. So you can go back and request that advance at this time. Okay, so that was a lot, but that gets us through all of the PPP section. And I am going to go ahead and turn it over to Mike now to cover the other components.
All right, can everybody hear me okay? Awesome. Let me get PowerPoint up. Sorry, everybody, I had a little bit of computer difficulty right as we were starting this presentation today. And also just wanted to kind of point out, so in the interest of getting the presentation out as quickly as possible, Kate and I have divided and conquered. And so Kate has really buried her time into the PPP2. I've buried my time into shoot, I got the wrong slide up. I've buried my time into the employee retention tax credit. So that's kind of why in the chat here, I've tried to respond to some of the questions as they were coming through, but to the extent that there were a couple of nuances in the questions, I just didn't want to provide some bad information out there. So I've provided answers to some, but not all. If Kate takes a look through those and has some answers, great, but we will definitely go ahead and do a Q&A document that we'll send out to everybody. I guess it doesn't want to do that for me. So
Mike, I can go ahead and advance the slides for you.
I'm sorry.
That's easier.
Yep, I'm getting there.
Okay.
So we want to cover just a couple of the kind of tax related changes, but we're going to go really quick if I can get to the right slide, because I do want to save some time for the employee retention tax credit. It's not new, but there's very significant changes to it. All right, so let's just cover a couple of the kind of tax related changes that recently happened in the new bill. So we do have some new stimulus payments coming out. It is $600 for each individual, $1,200 for each married filing joint taxpayer, and then also you get $600 for each dependent child under 17. There was talks of fixing this to say if the child was in college and they were eligible to be a dependent, you should still get the $600, but they did not fix that. So it's basically 16 and under, you get the $600. If they are eligible to be claimed on a dependence, so if your kids do have a job, file their own return, but they're still a dependent on your return, they are not going to be eligible for the stimulus payment. It starts to phase out at $75,000 for a single taxpayer, $150,000 for married filing joint. And the way that this phases out, so that's when it phase out starts. So the way it starts to phase out is for every $100 over that threshold, and this is an adjusted gross income, an AGI test. For every $100 over the AGI, it reduces the payment by $5. So you can see where the top end fully phased out number is different based upon if it's an individual versus if it's married filing joint versus if you have one kid versus if you have three kids. And all this is based upon your 2019 filing information. Just as the first time, it's on your 2019 filing information. If you didn't qualify in 19, you file your 2020 tax return and you do get it, you'll actually get it when you do your 2020 tax return. If you did qualify in 19, you do your 2020 tax return and you no longer qualify, there is not a provision for you to pay it back. So it's kind of a windfall if you qualified in 19 and you didn't qualify in the subsequent year. The basically the mandatory paid sick leave and expanded FMLA, the important thing here is the mandates have not been extended, but the credit has. So if an employer voluntarily is providing these benefits, you are still eligible for the credit through March 31st, 2021, but starting 1/1/2021, you are no longer obligated to provide these benefits. Section 139, this really isn't new, either in the CARES Act or in the recent bill. We just wanted to call attention to this. It is since President Trump declared the entire nation a disaster area, you can qualify for this 139 payments. And what it is you're able to essentially reimburse your employees for additional costs that they've incurred during the pandemic. And it's kind of a win-win. It is not treated as taxable income to the employee, but it is still tax deductible to the company. And the things that you can do, over-the-counter medications, childcare tutoring, work from home expenses, increased commuting, unreimbursed healthcare expenses. There's not a lot of obligation for the employer to get the receipts and all the details back. So we're seeing several companies out there doing $500 per employee, $2,000 per employee. Presently, there's no limit. There is some talk of putting a $5,000 per employee limit on it, but presently there is no limit of what you can do. A couple of other impacts. If you have a Section 7 loan and you've already received some months paid principal and interest in 2020, beginning February 2021, you're going to have 3 more months paid. And they also did clarify, along with the PPP not being taxable, the SBA paying the principal and interest for you via these SBA loans is also not taxable to the company. Unemployment insurance, where we had 600 before in the CARES Act, it's now down to 300 additional per week through March 14th, 2021. As far as charitable contributions, if you do not itemize, you will still get a $600 charitable deduction on your 2021 tax return. And for those individuals that are feeling very, very generous, as long as it's cash contributions to public charities, you can eliminate all of your income in 2021 for giving to charities. And then from a business standpoint, meals, the deduction historically has always been 50%. Spend $100 on a meal, you only get a $50 deduction. For 21 and 22, we're going to get a full business meals deduction. A couple of things that are extending. So unreimbursed medical expenses, the CARES Act reduced the 10% threshold down to 7.5. That change is now permanent as it relates to unreimbursed medical expenses. Section 179D has been around for a while, but is now making that permanent. The work opportunity credit was set to expire, and so that is now extended to December 31st, 2025. And kind of like the Section 139, I'm not sure a lot of folks know about the Section 127. So historically, an employer could pay for $5,250 of an employee's tuition, and kind of you get that win-win. It's not taxable to the employee, but it is tax deductible to the employer. So the 127 isn't a new thing, but what changed here is prior to the new bill, this happened in the CARES Act, and then the new bill just extended it. You're allowed now to have the payments, which includes principal and interest on student loan, payments, included in the Section 127 benefit, and that goes through the end of 2025. Okay, so that's, like I said, I just wanted to go really quick through that. I want to hit a couple items here as it relates to the employee retention credit. So why are we talking about this? Kate had mentioned earlier, when we first went through the whole process, we had to choose, do we want to get the PPP loan, or do we want to get the, what I'm going to call the ERTC? So do we want to get the ERTC? For most individuals, 90+% of the individuals out there, the PPP loan was better. So we went down the path of the PPP loan, and really we didn't have to dig deep into the employee retention tax credit because it really wasn't relevant for us. The new bill basically allows us to go back in time and retroactively get the ERTC, even if we got the PPP loan. The key here is that we can't get both forgiveness and the ERTC on the same dollars. So if we have $500,000 of wages and we need 300 to get full forgiveness, we can still use 200,000 if they qualify, and we'll go into that more. We can still use $200,000 of those dollars to get employee retention tax credits. So wages and healthcare cost, for which the taxpayer claims the ERTC are not eligible to be forgiven. Just want to make sure I'm stressing that. You can't double dip. And also, if you're thinking about the mandatory sick leave, you really can't double dip on that either. So if a dollar is getting reimbursed because it was part of the mandatory sick leave, that dollar is off the table for the ERTC. If you're using a dollar for PPP loan forgiveness, that dollar is off the table for the ERTC. All the dollars that are left are eligible to kind of run through the math here. Group health plan expenses. This is kind of a change. As the law was originally written, if you were not paying somebody, so if you furloughed somebody, but you were still covering their health care, you weren't paying them, therefore it didn't fall under the employee retention tax credit. The IRS issued some guidance, and the new bill formally fixes it to say, if you meet all the other qualifications and you're incurring health plan expenses for individuals that you furloughed, even though you're not paying them, you're still allowed to include the group health care or health plan expenses in your qualified wages for purposes of the ERTC. All right, so let's kind of regroup a little bit as far as, so there's new, this is something that's been out there, but now it's more relevant. So what is it? Basically, it's a 50% tax credit up to $10,000 per employee for the entire period, March 12th to January 1, 2021. And it's a tax credit, but it's not a tax credit against your income tax. It's a tax credit against your payroll tax. So what's at stake here is for every individual you have, if you meet all the requirements and have enough payroll left over from the PPP, you can get $5,000 per employee for 2020. So, okay, so how do we qualify? And this really is the most important place to start, because just like with the PPP before, if we don't meet either of these facts, then it's going to be still like it was before. It's just not going to be relevant to you. But if you do meet one of these facts, the dollars could be very, very significant if you just take $5,000 per employee, and they even sweeten the pot for 2021. So it even becomes more lucrative for 2021. And a little bit of a spoiler alert, the 50% decline goes down to 20%. So even if you don't meet the 50 in 2020, still hang on a little bit because you might need it in 2021. So you got to meet one of two things: full or partial suspension of your business, and that is during the calendar quarter due to government orders. So I got a different slide here. I'm going to go into that in a little bit more, I guess, detail. But full or partial suspension is key there, and it's because of government orders. Or, and this is an or, right? You don't have to meet both. Or a significant, and they define significant as greater than 50% decline in gross receipts, and that's comparing the same quarter of 2020 to 2019. Similar to the PPP, but the PPP was 25%. For 2020, the ERTC is 50%. If you meet the 50% test, so say in quarter one, actually I've got an example here. So once you have an eligible quarter, the quarters continue to be eligible until you get back up to 80% of gross receipts. But once you hit 80% of gross receipts, that quarter still counts. It's the next quarter that doesn't count. So here's a little bit of an example for that. So here's our gross receipts by quarter for 19 and 20. So we can see that we've got a 55% reduction Q1 19 compared to 20. So we've triggered the 50%. So now Q1 qualifies. So when you're coming into qualification, it starts at the beginning of the quarter. When you're going out of qualification, it ends at the end of the quarter. So Q1 counts. Q2 still counts. If you look at Q3, our sales are now 83% of what they were in 2019. So we've tripped this 80% threshold, but Q3 still counts. It's the first day of Q4 that no longer counts for the employee retention, tax credit. And we're talking about, does it count or does it not count? What we're really talking about is the period for which we're able to accumulate eligible wages. So gross receipts, what are the gross receipts? Gross receipts are total sales, less returns and allowances, and then also income from services provided. I thought this was somewhat interesting. It's kind of not as intuitive as what I would have thought in the beginning. Gross receipts for purpose of this test does include interest, dividends, rents, royalties, and if you happen to sell assets, it's essentially the net gain on those assets. So the assets reduced by the basis of those such assets. All those are gross receipts. If you started your business in 2019, then you basically say, if I started midway through the first quarter, then you extrapolate, right? You say, okay, so if I started, if I only had 1 month of sales in the first quarter of 2019, then I'm going to take that 1 month times 3 to get my full quarter of 19. And I'm going to kind of carry on forward. If you started in the third quarter, and let's say that you started the last month of the third quarter, you're going to take your last month times 3. That's going to count as your third quarter 19 gross receipts. And you're simply going to use that same number for the second quarter and the first quarter. So you extrapolate the receipts in any quarter that you started, and then you use that for any previous 2019 quarters. There is not a provision, if we think about this kind of full or partial shutdown or gross receipts reduction, if you started business in 2020, there's really nothing to compare to. So there's not a provision that if you started in 2020 to somehow back into what 2019 receipts would have been. If you started business in 2020, you are not eligible for the gross receipts component of this. You might still qualify based upon the government shutdown, but just not the gross receipts. So what do we mean by full or partially suspended? So number one, the orders must come from the federal government or state or local government that has jurisdiction over the business. Those orders must limit commerce, travel, or group meetings due to COVID-19. So we got to have orders that are coming from the government. They have to limit the commerce, travel, or the group meetings, and the orders must affect the employer's operation of its trade or business. Couple things to note here. So this does not include advice or encouragement provided by the public official. So they simply have a press conference and say, hey, we'd like everybody to stay home. That doesn't count. It also does not count as if the business just chooses to, right? It has to come from a government order. Now, the IRS, and we've got a link in here, the IRS has a great FAQ on all these scenarios, but let me just run through a couple of them to kind of help the group maybe get their minds around what are we kind of going after here. The thing to keep in mind is more often than not, it has to be directly affecting the business itself. So they go through an example of a software consulting firm that the individuals, it's not an essential business, but the individuals are able to telecommute, and it really didn't affect their ability to serve their clients. They do not qualify. It goes through a physical therapy office where, unlike kind of the service industry, if you're not physically with the individual able to do the physical therapy, then that does restrict their business. So they were a non-essential. It goes through a great example for a restaurant that is fairly liberal here in the sense of think about takeout, outside dining, inside dining. If they only have takeout, they qualify. If they have takeout and outside dining, they still qualify. If they have takeout, outside dining, and inside dining, but the inside dining, because of social distancing, is just fewer tables, they still qualify. So that's directly affecting it. As far as like in a retail setting, if the order is affecting the customer base versus the company, it doesn't qualify. So just the fact that people are told to stay home does not affect a retailer because that's not affecting the retailer directly. I get we can kind of argue that, but that's what their position is. What their position would be, if it really impacted you that much, then you're going to be able to meet the gross receipts test. I did think it was kind of interesting though, on the flip side, there is an FAQ out there from a supplier. So if you're a manufacturer and you were in an essential business, so the shutdown did not affect you, but your suppliers were not an essential business and the supplier had to shut down, that you do qualify for it. So you really got to read through those FAQs. There's a really good chance you're going to find an FAQ pretty on point with what your facts and circumstances are, and certainly give us a call. We'll be happy to kind of talk through those with you too. But it's full or partially suspended is going to be a very important thing to see if you qualify to try and get some of the benefits here. All right, so qualified wages. Look at the time. So qualified wages, it's really, really important for 2020 to look at 100 full-time employees. For 2021, that goes to 500. But let me just kind of get through 2020 here first. And let me kind of jump over to the right-hand side of this slide. So full-time employee. So notice it doesn't say full-time equivalent. It's a full-time employee. So if somebody doesn't meet the test, they're not a 0.5 employee or a 0.8 employee. Our interpretation is they are not a full-time employee. We had the same circumstance when we were rolling out Obamacare. As far as a full-time employee is a full-time employee, there's not kind of this proportionate concept. So just like Obamacare, it's 30 hours per week or 130 hours for the entire month. And it's just simple. They either count as an FTE or they do not count as an FTE. It's gonna be really important to do that whole math. You do it for each calendar month in 2019 and then divide that by 12. It is pretty kind of intuitive if you started business in 19, or even if you started business in 2020, you basically take all the months that you were in existence and you divide by however months that you were in existence. So calculate the FTEs by month, divide by the number of months that you existed in either 19 or 20. So what's the big deal? If you have greater than 100 full-time employees, the only wages that qualify are basically wages that you're paying people to stay home. So they have to be wages paid to employees that are not providing any services. If you're under 100, well, equal to or 100 full-time employees, then all of your wages count. So if you are subject to a government shutdown, if you have gross receipts that have gone down by more than 50%, and your total payroll is $100,000 per quarter, then you get to take the ERTC on the full wage for that entire quarter. Versus if you had greater than 100 full-time employees and you had 10 people sitting at home, it's only those 10 people sitting at home. If you're over 100, there is some guidance out there that basically says if somebody's working 30 hours out of 40 hours, well, you still get that kind of the 10 hours, right? So if you are legitimately paying people to stay home, it doesn't have to be an all or nothing. They can be coming in part of the time. It doesn't kind of preclude you from in a salary position where you're not kind of tracking hours. It doesn't necessarily preclude you from counting, paying people to do nothing just because their salary, but there is a requirement of documentation. There is a requirement of being able to prove that they were doing nothing. Lack of productivity doesn't count. So just being able to say that, well, my folks can't go networking, they can't go to business meetings, they're at home, they're not used to it. I'm still paying them for their full salary, but I just know they're getting less work done. That doesn't count. It has to be something like, we're going to obligate you to answer emails and phone calls Monday, Tuesday, Wednesday, take Thursday, Friday off, do nothing, take Thursday, Friday off, and we're still going to pay you for the 5 days. So if you're over the 100 full-time employees, that's kind of what it would have to be. Unlike the PPP, unlike some of the other stuff out there, this does have a tax impact. So if, and it's a 50% credit, so if in a quarter I have $100,000 of wages, of qualified wages, and therefore my credit is $50,000, when I take my tax deduction on my tax return for wages, I don't reduce it by the full $100,000 of qualified wages, but I reduce my wage deduction by the $50,000 credit that I got. So qualified wages up to the amount of the credit may not be deducted for income tax purposes. Qualified wage exceptions. If you terminate an employee, those are not in pay severance, those are not qualified. Have more than 100 FTEs, and just during the kind of qualifying period, you're simply paying for past vacation, sick time, because they weren't providing services during that period, those do not qualify. For 2020, this goes away in 2021, but for 2020, there is this rule that basically says you need to look at the rate of pay in the 30-day period immediately before the eligible quarter, and you're limited to those wages. Essentially what it's saying, you can't pay people a bonus during the qualified period just to get more of a benefit. You have to pay them comparable amounts. In the recent bill, they said, why does that make any sense? If we want to make it more lucrative for our employees, isn't that kind of what we should be doing? So they actually changed that in 2021, that this bonus concept is gone. You can increase their pay, but for 2020, we've got this 30-day period look back. Wages paid to a related individual. I know we got a lot of family-run businesses there. So anybody that is of a relation, you do not get to include those, I guess, relation to the owner. You don't get to include those wages. And as I kind of said before, each dollar can only really be used once. So if you were using it for this mandatory family leave or sick pay, those same dollars cannot be used for the employee retention tax credit. This is full-fledged IRS aggregation rules. I'm not going to go into that much depth on the aggregation rules themselves. We could have an entire seminar on just the aggregation rules, but it's the full IRS aggregation rules with the 50% of majority ownership and then the 80% of 5 or more people. All of that is at play, and you got to go through all these tests as one aggregated group. And where are the areas where the aggregated group becomes relevant? Well, this one is actually a good one. This notion of being partially or fully suspended of all the different entities that you might have to aggregate together. as long as one is partially or fully suspended, the entire group qualifies. This one can work against you in computing the 50% drop in receipts. You got to do this calculation quarter by quarter for all the aggregated businesses. And then for the FTEs, it is all the aggregated businesses that must be added together to compare the FTEs. Once you kind of pass or don't pass, you're still going to file your 941s. You're still going to go through the process entity by entity, but this really just determines, do you qualify, and how do you accumulate the qualified wages based upon the number of FTEs that you have. All right, so how do we claim the credit? If we go through and we say for a couple of quarters here, I've got $500,000 of wages, so I've got $250,000 coming. This is going to be one of those areas where I think there's going to be more questions than answers. I think we're going to have to play it through, simply put, calculate, go through the details, ask all your questions, get your mind around what credit do you have coming towards you. As soon as you know the credit that you have coming towards you, you've got that next payroll, the amount of withholdings, and this is kind of it's kind of surprising what they're allowing us to do. The amount of withholdings that you're going to send to the IRS that's on the 941. So FUTA is not on the 941, so it's everything that's on the 941. So all those withholdings on that next payroll, say I got a $500,000 of qualified wages, I got $250,000 coming my way. I go through and on my very next payroll, I've got, this is employee income tax withholdings, the employee's share of Social Security and Medicare, and the employer's share of Social Security and Medicare. So I've got $250,000 coming, and on the very next payroll run, I'm sending $50,000 off to the IRS for these categories. Call up a payroll company, call up your payroll department, and tell them don't. Just simply keep the $50,000. You've now paid yourself $50,000 of that $250,000. And there's added lines now on the Form 941s that at the end of the quarter, you kind of reconcile this. You reconcile it for the amount of credit you're taking for the mandatory family leave and sick. You're also reconciling it for the amount of money that you're taking for the employee retention tax credit. There's an additional form called this Form 7200 that if you need more, so you got 250 coming, you got $50,000, you're like, I don't want to wait 5 payrolls to be able to pay myself my full $250,000 that I have coming. You can fill out this Form 7200, basically submit the form, and they're supposed to turn it around in 2 weeks. We'll see if they're able to do that, but you fill out this Form 7200. I just got 50 grand. I got 200,000 more coming in. I fill out Form 7200, putting $200,000 on that, send it in, and supposedly in 2 weeks, you're going to get a $200,000 check from the IRS. So that's how you claim the credit. All right, last slide here, changes to the 2001. I've kind of hit on these as I've gone through, but just to make sure that we're all on the same page. All those details were very specific to the 2020 calendar year. Now let's talk about 2021. They extended the program through June 30th, 2021, and all these things are quarter by quarter. So we're looking at Q1 and Q2 of 2021. The 50% credit is now 70%. We could have 10,000 of qualified wages for all of 2020 per employee. Now it's 10,000 per employee per quarter, so up to 20,000 if both quarters qualify. The 50% reduction is now down to 20%. I'm going to skip over this little nuance here because I'm not sure it's going to, I guess, relate to a lot of people. And the 100 FTEs is now up to 500 FTEs. And as I said, the 30-day rule preventing bonuses is now gone. And again, want to stress all these changes here, even though we can retroactively go back in time and get 2020, all these changes relate only to 1/1/2021 through June 30th, 2021. And then a new rule for 2021 is kind of formalizing the advanced credit process that you're able to, for any quarter, fill out this Form 7200 and get an advanced credit equal to 70% of the average quarterly wages that you paid for that same quarter, 2019. And we've got a link there for the FAQs. Sorry about going really, really fast through everything there, but I did want to kind of get through that information. I'm sure there's a ton of questions. I haven't been able to monitor the chat. We will get back to those. But I wanted to get that information out there so you guys could start thinking about this and how it interplays with the PPP-1 and the PPP-2.
Well, I'd like to thank Kate and Mike for their insight today and thank everyone who's been on the webinar. I know we've kind of run out of time, and based on what I've seen, we've answered a lot of the questions. But as noted, we will be sending out an email with the recording. I've seen a lot of requests for email of the slides in the presentation. We can do that as well. In addition, I've seen a lot of questions about our calculator. We will be updating the PPP, the original calculator, and we're determining the best approach for the sort of second round calculator. So more to come on that. And as Mike and Kate both said, we will be putting out frequently asked questions sort of document, which should be coming out shortly. So again, we appreciate all of your questions. We appreciate you being on here, and hang tight for the correspondence. Keep your eyes out. All right. Thank you, everybody. Have a great rest of your day. Enjoy.
Thanks, everybody.
Thanks, everybody.